Let's go back to one of our top stories that we are tracking for you today, and of course get analysis after the Supreme Court of Appeal this afternoon has heard that there is no proper appeal before the court, as there has not been a change of status as contemplated in one of the rules, Rule 15 of the Uniform Rules of Court. To speak more on this, let's now get our analysis from legal analyst Melusi Xulu. Melusi, thank you so much for patiently waiting for us. Of course, we are tracking a number of developing stories today. But just going back to this particular court case at the Supreme Court of Appeal, let's start by having you unpack the significance of this particular rule, Rule 15, Section 1 of the Uniform Rules of Court, and how likely it is to impact and even have bearing on this particular case.
Good afternoon, Nat, and to the viewer at home. If you look at Rule 15 of the Uniform Court Rules, it basically says whenever a party dies or ceases to be part of the proceedings, any person, whether it's a curator, executor, or a legal representative, can apply to be, to substitute that particular party. So what do we have here? We have a situation where Advocate Mkhwebane, when she was a public protector, she was doing these proceedings under the institution. But it so happened that when she was proceeding, in particular to appeal, she was no longer a public protector. So there are issues of whether is she the right person or did she do it correctly to be part of the proceedings. So there has to be an issue of substitution. That is why when you heard Chad was kind of mentioning that, could it be that they don't have the jurisdiction to hear the matter? So that will be a critical issue. But if you heard what the advocate Dali Mpofu was saying, he was basically saying ultimately, yes, there can be unreasonable delays, there can be procedural hurdles, so to speak. But ultimately, Section 172, which we'll discuss later, subsection 1, paragraph A, will have to be looked at as well in the Constitution, where it says any act that is or law that is inconsistent with the Constitution must be deemed to be unlawful, so or invalid rather. So I think that was what will play in this, whether the courts will decide whether, despite the fact that there are procedures that she was supposed to meet, can they look at the merits of the case, and then obviously then they will decide whether do they have jurisdiction. So that will be interesting.
And I want to understand, so is that the technicality then that was being discussed in terms of the capacity upon which the former public protector now finds herself in? I mean, it was deliberated, as you say, at length by, of course, her counsel, Advocate Mpofu. But just talk to us about what are we likely then to see on that particular matter when the court then does make its decision?
I think at the end of the day, if the argument of Dali Mpofu is followed, basically it says, yes, maybe there may be some reasonable delay, first of all, to come to court. When he was discussing the Gijima case, I think you did hear him mentioning it a lot, where basically also is to look at the fact that despite all these things, ultimately what we are in court for is to look at the conduct of the chairperson of the impeachment hearing, Dyantyi. So in that case, Dyantyi, as you all know, there was an application for him to be recused. That's first of all. And secondly, there was a certain instance where Advocate Mkhwebane did not have a lawyer. So there were those issues. So, all right.
Melusi, let's leave it there for now, and we'll continue, of course, on this particular matter as the court proceedings go ahead. But Melusi Xulu, let me thank you so much for your time.